May it please the court. Good morning, Judge. As you're aware, McDuffie County, like all the other counties, is here because we want to ensure that a proper election has been fairly and honestly conducted. As we've discussed with the court from the start of this matter, the counties are here sharing information, trying to explain what happened, how we ended up here. But at no point does the county have the burden to establish any of this. It is up to the petitioner to clearly establish that a violation of the election process has occurred. The county is here to share the information. That is what we're doing. To that end, you've heard from Ms. Phyllis Brooks twice on the stand, our elections director. She's acknowledged that issues occurred. She has been very upfront and straightforward with the court. She's acknowledged that mistakes were made. Not intentional. We intend to correct these going forward. But at the first mention of issues, the first thing that Ms. Phyllis did was immediately inform her board and immediately own it and accept responsibility for those incidents before she even had the opportunity to investigate anything. But on December 3rd, she was provided a list by the Secretary of State. And the first thing she did that day was go and look in Jarvis to see what districts these voters that had been provided to her, to see which one they were assigned. Your Honor, she found that 32 on that list on White Oak Road were listed incorrectly by the Secretary of State's list and correctly by her. She found another 21 on Stagecoach Road. The Secretary of State's list was incorrect and that she had correct in Jarvis. As I mentioned, one of those being a member of our Board of Elections and his family. Of all people to know where they live and which House district they're in. It's a mile away from the district line. She had her Board of Elections member correct in Jarvis. Now, you heard testimony from Mr. Davis, who he said that at some point from my review of these records, from December 6th through January 3rd, a change was made. Your Honor, that's not the evidence in front of this court. He is looking at documents. You've heard testimony that Ms. Phyllis Brooks put her eyes on this information on December 3rd, and that those voters in Jarvis showed that they were in the correct district, 125. Now again, Your Honor, McDuffie County is here to bring information to the court. We just want a proper election. We are not vested in which one of these candidates win. But at the same time, we have to support and show the court and provide all the parties what we're aware of, the information that we have. But again, at no point does the petitioner's burden to clearly establish that there has been a violation of the elections process shift to McDuffie County. But to this end, to try and provide the information, you heard from Ms. Phyllis about this Jarvis records. You have these Jarvis records. Yes, she printed them on January 10th, right before the first scheduled hearing in this matter, the following Tuesday. So the court may recall that was the day that we had an ice storm. Ms. Phyllis came into her office to print those records out that she had looked at previously, that she had looked at on December 3rd. And she printed those out for the court's benefit to bring the information into the parties. We provided it to everyone. They've had it. Then last week, and this is all this information being shared with the parties as we felt that it's our obligation to do. She then went and realized there was a question about the date. So she goes and she pulls the audit history. You have that audit history from Jarvis. It shows that there have not been a change in there since the election. Now, yes, there were questions asked about what it shows, what it does not show, but Ms. Phyllis's testimony is those 24 White Oak voters, they are in House District 125, that their Jarvis information from the election day until now has shown that they were in 125. And she has testified that is all that she has access to. And she's looked, and in McDuffie County, our records have these 24 voters in the correct district and receiving the correct ballot. Yes, she cannot answer to how this happened. You'd have to ask somebody from the Secretary of State. We don't have anybody here from the Secretary of State. But, Your Honor, the burden is not on Ms. Phyllis to come forward and explain this. The burden is on the petitioner to clearly establish that there's been a violation of the elections process. Ms. Phyllis has shared all that she can. She would never misrepresent to the court in trying to answer and assume what happened. She does not know. But we don't have the person here to answer. But again, that's not her responsibility to bring that person before the court. That's on the petitioner, Your Honor. Your Honor, if you have this evidence, and Ms. Phyllis has acknowledged these voter certificates, she can't explain them. She can't explain the electors list, all the things Mr. Evans listed. But what she can explain is Jarvis, and that is what she has explained to this court. And right there is conflicting evidence, the information. And we don't clearly have established that there was a violation of the elections process. As Your Honor noted, without those 24, we are not hitting the threshold of the 48, Your Honor. But the court doesn't even need to get to that. And I want to talk briefly about the burden here, Your Honor. And I'm sure that some of the other attorneys for the respondents will address this as well. As I've said a few times, the party contesting the election has the burden to clearly establish a violation of the elections procedures. It would have been easy in this situation to bring in those voters, those White Oak voters. Ask them, which ballot did you receive? The petitioner could have clearly established by bringing them in to ask them that. As Ms. Phyllis testified, White Oak Street is right here outside this courthouse. It turns into White Oak Road. We're within a couple of miles of where these voters are located, sitting here today in this courthouse, in this government center. We have witnesses that were subpoenaed, 29 witnesses from as far away as Marietta, where all we had to do was reach out a couple of miles to get that answer in here. And again, Your Honor, that burden is with the petitioner to clearly establish that there's a violation. Your Honor, this race had around 27,800 votes cast. It was decided by 48 votes. There have been testimony, and McDuffie County has acknowledged that there were some voters, for various reasons, that received the wrong ballot or that may have cast a vote incorrectly. But what the petitioner has argued is that there are 11 voters that are disenfranchised due to ballots cast by qualified voters in 128, which omitted the contested race due to them being misassigned in House District 125. Petitioner, those are referred to as disenfranchised. The petitioner has alleged that there are three votes cast by movers, persons that resided within 128, but that they moved, and because of their relocation, they were outside of House District 128 and cast a vote. And the last group, which we've talked about, includes the White Oak voters. These are non-resident voters who are alleged to be given improper ballots for House District 128, but were not voters qualified to cast them because they actually resided in 125. There's no allegations that the ballot itself was improper. It's that the voter and the vote cast, if one was cast, was an improper vote. Your Honor, while some of these various voters I just mentioned are in dispute by other counties, McDuffie County acknowledges that if the 11 alleged disfranchised are found to be so, that they, combined with the three movers that did come in here and testify that they voted down ballot, then those 14 ballots should be discarded. But that's 14. We still got to get to the 48. None of the 44 alleged outsiders may be credited towards that 48 needed in order to require a new election. And it's because the burden and the standard requires that those voters, that it's required that evidence show they actually cast a vote in the House District 128 race, because that ballot, Your Honor, was proper. They were not a qualified elector within 128. It has nothing to do with the ballot. It is with the vote cast. Mr. Evans is arguing that those ballots are improper. That is the one question that is before this court on this. And the court needs only look to the Meade case that has been cited by everyone. Again, it's up to the petitioner to prove that these illegal votes required to show that they were actually cast in the race in House District 128. Your Honor, in Meade, the court determined the ballots received by certain voters qualified to vote in that race were irregular because the ballots on their face had the wrong name on them. That is what made it an illegal ballot. The ballot stated Thomas Meade instead of Howard Meade. The key was they were qualified voters to vote in that race, and their ballot had the wrong name on it. So I've said those cast legal votes on an irregular ballot. Those would be, and the court specifically referred to on page 271 of that opinion, that those voters were disenfranchised. That is exactly what Mr. Evans has referred to as the 11 who were in 128 and alleged to have voted outside or have received a different ballot. They were disenfranchised. Those are the ones, assuming the evidence shows that to be correct, we don't disagree with. But that's it. These others, and there's no required showing under Meade of whether they voted or not because the ballot, because they were qualified and they received a ballot that had the wrong name on it. Those were wrong ballots, not wrong votes, Your Honor. We have the exact opposite for the 44 outsiders here. What is alleged is they received a proper and regular House District 128 ballot, but it is indisputable that the ballot did not omit the name of either one of the candidates that were qualified. And it's also indisputable that these 44 outsiders are not qualified voters in House District 128. If we take the petitioner's allegations as true, all of these people received a proper and regular House District 128 ballot as a voter who was not qualified to vote in 128, making it an illegal vote, Your Honor. Your Honor, we heard from the three movers. They came in, they testified, they voted down ballot. Those, McDuffie County would agree if the evidence shows that they did in fact move, that those three should be counted because they came in front of Your Honor and they would have they would have had a wrong vote that should not have been counted. The ballot was proper. Your Honor, that makes the total 14. Now again, we haven't heard from these 24 White Oak voters right here within a few miles of us. We haven't heard what ballot they received. We haven't heard if they voted down ballot and cast a vote in House District 128 race. Your Honor, that is all it would have been taken for us to have the answers to these questions that the court is wrestling with, is to bring these witnesses in, where we had witnesses far away from Marietta subpoena. We also haven't heard from the 18 voters that McDuffie County stipulated were in 125, and Ms. Phyllis admitted received a ballot to vote in 128. Again, those are wrong votes that the court has to hear from the voters to hear that they actually cast a vote in the House District 128 race to determine that that will be an illegal vote. Your Honor, because this evidence is not here, the court cannot make a finding that the petitioner has met his burden to establish this. Your Honor, I'm sure some of my colleagues are going to hit on this and probably do a much better job than I have explaining this. But at the end of the day, for two reasons, we feel that the petitioner has not clearly established that this elections process should be, their contest should be upheld. First, we got the 24 voters on White Oak that, based on the Jarvis record, received the correct ballot. Second, and wholly separate, we don't have any evidence of these 44 outsiders from District 125 that they actually cast a vote in the House 128 race. Your Honor, I thank you for your time. Appreciate you being here.
Morning, Your Honor. I appreciate the court's patience and indulgence from hearing from all of us over the past 2.5 days. I just want to start by saying yesterday, Petitioner's Counsel didn't seem to understand the board's motivations for defending the case. And I just want to say quite simply, we're here to preserve the integrity of what we believe was a fairly conducted election that accurately reflects the will of the people of the 128th House District. It makes no difference who the challenger is or what the ultimate outcome will be to the board. Our concern is ensuring that the election was administered in compliance with the law and that the will of the people was accurately expressed. And to suggest that the county board should just concede to unproven allegations is, in our view, a position that will be injurious to our electoral system. But that's what this case boils down to. Did the petitioner meet her burden to require the court to grant her the dramatic remedy that she seeks? And we don't think they've met that burden. And for many of the reasons that Mr. Dunaway outlined, we don't believe they met that burden, and for other reasons too. And I'm not going to go through everything Mr. Dunaway said again because he was very articulate, but I am going to touch on a couple of the points he made and just add a couple things to them. But before I do that, I would like to talk about the petitioner's expert's testimony, Mr. Mark Davis's testimony yesterday. In my client's opinion, it requires the willing suspension of disbelief to believe the allegations that their expert made with regard to Ms. Daniels and the Taylors, and perhaps Mr. Shelton too, but certainly with regard to the first three. He testified repeatedly in this trial and in other trials that surveying is the most accurate method of determining property lines and boundaries. He's been quoted by the Supreme Court of Georgia as saying that in testimony in the past. He admitted that the surveys that I showed him for the Daniels and the Taylors showed that they lived in counties outside of House District 128. But then he told the court, when questioned by both myself and Mr. Evans, that he's confident that those same voters were located within House District 28. We had an expert here with degrees from Georgia Tech and Harvard to tell us that Mr. Davis's methodology is flawed, to put it mildly, but I don't think we needed that to conclude that it strains credulity to put up a witness who stood here before us and said the surveys are the most accurate thing, but believe that the people live in another county contrary to what the survey states. So, when we're talking about arguments that border on frivolous, I think that's one of them. The petitioner, he hasn't mentioned it yet. She hasn't mentioned it yet today, but I expect her counsel to mention systemic irregularities and contend that this may be a systemic irregularities case. It isn't. We believe they know that. To our knowledge, there's been one case in the state of Georgia that was overturned in that way, and in that case, you had a candidate who I believe was standing outside of a polling place and checking off names on a list, essentially a voter intimidation list. That would be like a case where someone picked up a stack of ballots and went outside and sat under an oak tree and filled them out for a bunch of people. That's such a high bar. We haven't touched on any allegations today or over the past couple days that would make this a systemic irregularities case. So we want the court and both sides here to be clear on what the law is. There have been many cases that fit the fact pattern of this one that have been considered by the Court of Georgia. We've focused on a few. We've talked about the McIntosh versus DeVerger case. We've talked about the Meade case, Howell versus Fears. The Fuller case has come up this afternoon. But there are a legion of cases that say the same things. But Fears and Meade are two of them. And they stand for the proposition that in limited, narrow exceptions, when you have a sufficient number of irregular or illegal ballots, then you can depart from the long-standing traditional rule of having a sufficient number of votes to cast the results of the election in doubt. In other words, if you have a case like Fears, where the race was actually omitted from the ballot, you don't have to haul everyone in here and ask them, would you have voted in that race? You can't, because it would be impossible to ascertain with any degree of certainty what that number would be. That is a sufficient defect in the ballot to force a new election, where you don't have to go through the long-standing traditional rule of finding a sufficient number of votes, which in this case, as the court knows, would be 48. In the Meade case, as Mr. Dunaway said earlier, they put the wrong name on the ballot. Again, you have people who were not even allowed to vote for the candidate who was running because his name wasn't on the ballot. That's what made it an illegal or irregular ballot. For the folks, now they allege 11 who were disenfranchised. I think we've clearly shown that 3 of those people were not disenfranchised, that they didn't live in the district based on the surveys and deeds and property tax records. And then Mr. Shelton, we don't know if he lived there or not. But for those 11, if you buy that all 11 of them were disenfranchised, it's because the House District 128 race didn't appear on their ballot. And we agree that makes it an illegal ballot. If you are in House District 128 and you get a ballot and it doesn't have House District 128 on it, that is an illegal ballot. You don't have to haul those people in here to have them testify whether or not they voted in that race or would have voted in that race, because they didn't have the opportunity to vote in that race. But with regard to the outsiders, the 44 he referenced before, you have to show that they actually voted in this race and that they were ineligible to do so. It's not enough to show that they were ineligible to vote in this race. They didn't get, and if they were, let's say all 44 of them are in House District 125, and they voted improperly in House District 128 for the purposes of argument. If this was an elections contest to overturn the race in House District 125, and those 44 people had gotten 128 ballots, and they were supposed to be able to vote in 125, they are disenfranchised as to 125. They're not disenfranchised as to 128. They got a proper ballot. They didn't get to vote in House Race 125 because House District 125 wasn't on their ballot. But we're not here to contest House District 125. We're talking about 128. So they're illegal voters. Their ballots are not illegal. And that is borne out by the case law. And I know colleague, Mr. Sparks, is going to talk about that further. But it is a critical distinction. I mean, it is the make or break as to whether we have a new election in this case. And these two cases, Howell versus Fears and Meade versus Sheffield, they have outlined the limited circumstances where you can depart from the traditional standard. And that's not what we have here. If we had 48 disenfranchised people in this case and thought they could show it, we wouldn't be having a trial. We would have conceded it. But that's not what we have. We have 11 alleged disenfranchised, and every one of those who they proved should go to their number. And we have 44 outsiders. And none of those can go to their number under existing law and existing precedent unless the court wants to change the law today. And I heard the court earlier this week, the court's not into changing the law. So it is our view that if the court rules that we have a new election on the basis of these 44 alleged outsiders, that we, are extending Meade in a way that it has not been extended by the court before. It'd be creating new law, and it's up to the Court of Appeals and the Supreme Court to create new law. If we follow the law, if we follow precedent, the petitioner has clearly not met their burden in this case. Give me a moment, Judge. And Meade says that. I'm going to quote it. It says, in the limited circumstances where a ballot omits the name of a qualified candidate, it is illegal. And if the number of those ballots exceeds the margin of victory, then that illegality requires that a new election be held. I mean, let me say that again. It says, in the limited circumstance where a ballot omits the name of a qualified candidate, it is illegal. And if the number of those ballots exceeds the margin of victory. If the number of those ballots exceeds the margin of victory. You don't have that here. You've just got the 11 they alleged where the race was omitted from the ballot. The 44 are not in the same category. And that case also articulates the rule that in other circumstances you must determine that a sufficient number of voters have voted in the race to cast the results of the election in doubt. That has not happened here. We'd ask the court to keep that in mind as they consider a ruling in this case, and we thank the court for their time.
Good morning, Your Honor. Adam Sparks, Representative Jackson. If you hear any ripping and rustling over there during my co-respondents' counsel's arguments, it's because I was trying to avoid redundancy in striking sections of mine that were covered adequately by my colleagues. Now, as the representative for the successful candidate in this race, there are a couple of concerns that are peculiar to my client. I'll try to cover them briefly, provide a little about the law that we believe the court should consider here, maybe a little about the evidence that has not been stressed yet, including Your Honor's question before closing, and a little about the context and perhaps in response to some of the opening. So, regarding the law, I believe Mr. Dunaway and Mr. Moses have well covered the law that applies to this case. To be crystal clear, this is not an irregular ballot case. This is an illegal voting case. That is how petitioner pleaded her case. And the court explained why in Meade v. Sheffield, but of additional relevance here in McIntosh County Board of Elections v. DeVerger. That's D-E-V-E-R-G-E-R. DeVerger, 282 Georgia 566. And it made two important points. First, it affirmed that distinction between irregular ballot cases, which is Meade, which is not this case, and illegal voting cases, which is this case. DeVerger was actually written by Justice Hunstein, who authored the special concurrence in Meade, further elaborating on the distinction between these two types of cases. Second, DeVerger affirmed that for ballots cast by voters in the contested case who are ineligible, for example, because they moved away months before the election or received the wrong ballot, the petitioner has the burden to show that they voted in the contest being challenged. DeVerger made this point extremely clearly. If you look at Division 1, you can see that Justice writes, and here's the money quote, the votes alleged to have been illegally cast, quote, were cast in the challenged race. And petitioner failed to show this. Thus, they should not have been considered in assessing whether the results of the election have been placed in doubt. Now, the Supreme Court did grant the contest petition there, but only because, as it explained in Division 2, the evidence of record showed that 4 voters were wrongfully denied the chance to vote in the contested election, and that was equivalent to the margin of victory, exactly 4 votes. DeVerger explains very well the distinction, perhaps the disconnect, between the explanations of the law that Your Honor has heard from the different sides in this case, and I commend it to the Court's review. There are other legal reasons as well that we believe petitioners...
That was at 282 Georgia what?
566.
566.
Yes, Your Honor. Now, Fuller, which petitioner briefly raised in his opening, is a 2008 case, but it also only briefly glances on Meade, and there the allegations were insufficient to reach the margin of victory, which is why it only touched on it glancingly, and that was also an illegal voting case, just to cover the timeline. There's a couple of other legal reasons we believe the petition should be dismissed, Your Honor. For one, the Georgia Supreme Court has been extremely clear this year that challengers who do not act with dispatch to resolve issues that could have been raised and resolved before an election takes place should not have their challenges heard. Now, this is a slightly different context. I want to be candid with you. This is about candidate qualifications in 2 of the 3 cases the Court has issued this year. And this is all in a trial brief that at some point today my office will have filed on the docket if you'd like to refer to it. But it cites the Ponder v. Davis case, the Catoosa County Republican Party v. Henry case, and the Miller v. Hodge case. The point here, and as Your Honor may recall from my cross-examination of Mr. Davis, a number of these issues petitioner has claimed have been longstanding. They've been in open records. They've been in public records. This is not something that jumped up on the eve of the election. These are issues that could have, and perhaps should have, if they are, as petitioner has alleged, been addressed beforehand. But to now come back in the guise of an election contest to try to address these flaws after the election when they could have been discovered beforehand is a disfavored posture before the Georgia Supreme Court. I'm not going to tell you that Ponder and Catoosa County control this case because it is a different context. But it does shed light on where the appellate courts are going and how they have analyzed similar issues in the past.
You're asserting that the burden is on a candidate to make sure everybody's assigned to the right district before the race?
Not in every situation, Your Honor, but with these specific allegations and the evidence that have been put forward into the record, the representation has been made that they've been known and were long-standing before the case began. That is my point. Again, wanted to make sure that Your Honor was aware.
That may work in Atlanta. I don't know.
I appreciate it.
We have to obey the same law, I understand.
Yes, Your Honor, statewide, absolutely. Now, as it comes to the facts, I think...
Qualifications of candidates, obviously, they should bring that up well ahead of the race, if it's known.
If it's known, yes. That's the key.
Expecting the candidate to go on websites and all this other stuff to figure out where people live, I don't know about that.
Well, I understand Your Honor's point. Again, I'm making sure Your Honor is aware of the entire legal context. That's all. Now, in terms of the facts, I think you could tell from petitioner's opening that he is sprinting from the burden as quickly as he can. This is petitioner's burden. I thought it was interesting that in one breath in the opening, it was claimed that this is an ordinary civil case to which a preponderance of the evidence standard applies. And in the very next, he analogized a presumption that election returns are valid to be akin to the presumption of innocence afforded an accused criminal defendant, which, of course, has a standard of beyond the shadow of a doubt. Now, the correct standard, I would contend, is found in the Martin case that we've discussed, 2019 Georgia Supreme Court, and that's clearly established violations of election procedure, causing the results to be placed into doubt. That's the standard, and that sticks with petitioners throughout trial. There's no contrary case law that I've seen, that's for sure. This is not an open and shut case because you have conflicting factual and expert evidence on important issues before the court. The only election official who has examined this question of what ballot these voters received, about whether it's contested, which ones on White Oak Road, for example, actually received, is steadfast and emphatic that the records from the statewide voter registration database show they received a ballot vote in HD 125 just as they should have. I understand petitioner's expert has offered his opinion, and just like all of us, we have many opinions, but he has not offered for his expertise on the law, on election administration, on computer science, and his opinions on these voter certificates, how they're created, when they're created, why they might show information we would not expect from other records. I don't mean this unkindly, but it's simply not competent evidence, Your Honor. It's not something he's allowed to offer. And arguing ad nauseum that something is uncontroverted or unequivocal simply does not make it so. There is a divergence in the evidence. It is unusual, but it has not been answered by petitioner, and that is her burden to carry. To the extent she could have brought in voters on White Oak Road who are alleged to have received a different ballot despite the Jarvis records disagreeing, that was certainly possible, as Mr. Dunaway has said. There were 97 voters named in this amended petition. There are 58 for whom evidence has been put forward at trial. There were 29 in the most recent notice of issuance of subpoenas that we saw were filed after the issuance of these subpoenas, and only 5 appeared to testify. None of them live on White Oak Road. None of them fall in the category of the outsiders about which we have spent so much time discussing over the last 2.5 days. You can't simply look to Mr. Davis as the arbiter of truth on this question. To the extent you need to look to someone, it's Ms. Brooks. Ms. Brooks is the one with the background, the authority, the expertise, the experience, and is in the best position to access and assess why there might be a conflict in the evidence. And in any event, as I admit, I am repeating myself, it is petitioner's burden to show. I don't want to belabor our assessment of the battle of the experts here. Your Honor was here for much of that. Obviously, I'm going to stick up for mine over Mr. Davis's, and so I won't belabor that. I will just point out that the weaknesses of relying on the visual translation of records prepared by tax assessors over the actual source of the authority themselves, survey and plat records, is somewhat troubling and makes it difficult to credit that experience. It's as if I need to go to the grocery and I need to know what I need to stock up on the next couple of weeks. I could ask my daughter, who then goes and asks her brother, who then goes and asks my spouse, and I might get a report back through that chain of events that might be right, might be an accurate reflection of the underlying data, or I could just go and ask my spouse. I could ask the authoritative source on what it is that we need for the next couple of weeks. One source is a better authority of truth than the other, and that's quite simply much of what we appear to differ about in terms of the experts. But with that, I'll try to leave that beyond. Forgive me for skipping around a little bit, Your Honor. As I said, I'm attempting not to be redundant while... You referred to a trial brief. Is that another case or this case? No, Your Honor. I was working on that this morning, and I don't know from my office if it's been filed as of yet. If it's not, it will be imminent in hitting the docket. In this case? In this case, yes, Your Honor. Thank you. I'm sorry, I was unclear. It's not required? Yes, Your Honor. I'm conscious of how fast I talk sometimes, particularly when I'm caffeinated. Citations and case law and stuff like that. Yes, Your Honor. That was my thinking. Anybody else who wants to submit a list of cases that you may have provided to me, again, quite frankly, sometimes my notes are not as good as they need to be, so feel free to do that. And you don't really have to do it in the
record, you can send it by email and send copies to the other lawyers, obviously.
I'll instruct my office to send a copy by email as well. Thank you for that note. Let's see. I heard.
Y'all all have my email, I think.
Yes, Your Honor. Briefly on the witnesses, Your Honor, I'm grateful for the voters who took the time to appear. That was, of course, mandated by process, but they were unfailingly pleasant and straightforward. And I do appreciate the voters coming to participate in this important proceeding. I know my client would want me to make that clear. That said, I have to part ways on the implication of the testimony of Ms. Bowers in particular. As I heard her testimony, particularly on cross, she appeared to state that she didn't form the intention to remain in Bullock County until January 2025. That's this month. That's also the same month that she heard of the existence of this case from agents of petitioner. I do think there's a difference in the record there, and I wanted to make sure the court knew that we were not necessarily conceding that.
I think she said 2024 start, but she said 2025.
I heard some variance back and forth as well. And I would submit that the evidence on cross is more persuasive. Of course, that is for Your Honor to weigh. Give me one moment, please. Don't want to belabor the point about the accusation of recklessness or frivolousness. I think it's poorly taken, but that should not be a surprise.
On the record, maybe Mom and Daddy quit paying for rent in 2025.
Certainly could be. Certainly could be. As long as Your Honor knows, it follows that even if it's conceded that certain voters living in 125, let's put this question aside for a moment, and again, to stress the law, petitioner's burden is still that they have to show that voters receiving a ballot with a race for which they're not eligible to vote, the petitioner still has to show that they actually voted in the contested race. That is just, it's crystal clear in the law. It has not changed, and that burden hasn't been carried. We all know voters or friends or family members who pull a ballot every 4 years. They vote for president, and then they put it in the scanner, and they carry on with their lives. And that's one reason why petitioner has to show this. It's the votes, not the ballots, that are alleged to be unlawful in sufficient number here. Concerning the voter certificates, and it's not our burden to answer that question, Your Honor, but I do want to address it because you asked us to. Petitioner has put forward no evidence of any of the other voter certificates in this case. It's interesting that there's a stack of those for the voters that they've picked to include in their allegations and that they've whittled down further to present to Your Honor. But I don't recall any voter certificates from any of the other 28,000 odd voters who voted in this case. It's a little hard to determine whether there's something is or is not improper about them, of course, without competent witness evidence to say so for one. But for another, there's no baseline. There's no control document to show what the issue might or might not have been. We simply don't know. And of course, speculation is not enough to overturn the results of a certified election. That's Meade v. Williamson, 293 Georgia at 149. My final point, Your Honor, and this may be unique to my client, this contest is not filed in a vacuum. And it's not just because there's a narrow margin, I submit. There is and has been for some time, a broader effort in this state to punish errors in election administration, to punish voters who make mistakes, to transform laws about voter registration and voter access into an exclusionary, punishing, and sometimes criminal regime. I will tell you there's several cases on these subjects that were filed recently or are still ongoing around the state that bring up issues and the type of analysis that I would urge the court to discredit, just like those in this case. And I know because I'm counsel of record in several of them, and I try to remain aware of the others. These post-hoc attacks on voter registration records of voters who are just trying to do their civic duty, they're highly disfavored. It is concerning that we are taking a judicial process that is used for bona fide problems with elections that need to be brought up to the judicial level and making these kind of wild claims against them. It concerns me. There are elections that have been called into doubt that have no business being in the judicial system. I would submit the 2020 presidential election was one of those. 2021 Senate runoff, which I defended a contest of, also not one of them, and a lot of people watching those too. I am concerned that crediting certain of these allegations and these claims is going to encourage that kind of behavior and conduct further. And I'm confident that Your Honor will apply Georgia law as it must be faithfully applied, and thereby demonstrate the resilience, the health, and the steadfastness of the rule of law under our system. I'm very grateful for the Court's time and for the opportunity to present our case before Your Honor. Thank you.
Anyone else?
Judge Brandon Palmer on behalf of the Honorable Todd Blackwell, Baldwin County Election Superintendent during the election. I'm not going to rehash anything that's already been stated, but on behalf of my client, we would adopt the legal arguments that have been made by my colleagues and ask that you apply the standard as it goes toward illegal voting cases. We believe that is the proper standard in this case, and we would ask that you apply that standard and uphold the election and find that it was conducted in a fair and legal manner. Thank you.
Your Honor, if I may use the podium,
You may.
I will be briefer than anyone else who has talked except for Mr. Palmer. I don't aim to be much longer than him. Your Honor, Scott Kelly, I'm here on behalf of Warren County, and Judge Rachels, as you've noted, has not been absent from the courtroom but is attentive, and that's because the outcome of this case is important to Warren County. As the court recognized, we do have an interest. We have an interest in our citizens being protected, in the election integrity, and we also have an interest because if there's going to have to be another election, there are real practical consequences of that don't just affect the county, but every potential voter who might have to vote again in an election. When this petition was originally filed and then amended, there were 8 people named under the word county for Warren that were alleged to be improper. We ultimately, in a search for the truth, found 2 people who registered to vote in Warren County that shouldn't have. The evidence is before the court that those people put on their voter registration that they were in Warren County. They had a Norwood mailing address. Turned out they didn't. And I voluntarily entered into a stipulation with the petitioner's counsel. No problem. The others, we stuck to our guns. The other person, by the way, who we reflected in the stipulation was someone we had no record of as a voter. And really our stipulation, it was Kelsey Kent. She was registered in McDuffie, and we just pointed out that the parcel of property that was listed on her McDuffie certification was in Warren County. I've heard the arguments made, and I understand Mr. Evans' passion for his client and wanting to win in the case, but this isn't about extremes. Clear, undisputed, no way you could think otherwise. If it were, we wouldn't be here. This is very simply about the burden of proof, which is not, if you think a little bit more one way than the other, that you've carried the burden. The law is, correctly stated by my colleague, it must be clearly established. So that's the burden on the court. The court is correct. We've got a stack for these 24 voters on Whitehall Road where the absentee certificate indicates combo 132, which would suggest they got a ballot for 128. The problem is the Secretary of State's records, where these things come from, have been demonstrated to be wrong. And that's how the petitioner has chosen, which is, of course, counsel's right, to choose how they present their case. But in choosing to present their case, they forewent the best proof, the voters, and instead want you to rely on a hired gun, Mr. Davis, who really doesn't have any firsthand knowledge of the Secretary of State's records, and what these documents say when they could have, and I submit should have, called the voters. They issued a lot of subpoenas, not one to anybody on White Oak Road. And I guess that's the most troubling thing to Warren County, is that, and I don't envy the court's burden, but I ask that the court apply the law and realize that burdens of proof are there for a reason. And to order a new election on this evidence, we submit is a stretch. When better proof was available, and the petitioner who bore that burden chose not to go down that road. Not one voter. If there had been at least one that would suggest the records from the Secretary of State, these certificates were reliable, that would have been huge. I suspect they knew they weren't going to be able to meet that burden. But again, that was Mr. Evans' choice. We just ask that, you do what, reach a verdict, judge, that speaks the truth. Thank you.